Hey everybody, welcome to Lawyer Live with Matt the Lawyer. I am Matt the Lawyer, Matt Johnston, coming to you from Frederick, Maryland. So before we get started, I do want to remind everybody, hey, take a quick little jaunt over to mattthelawyer.com. You can sign up for the email newsletter there. You can also get a little bit of advance notice on a book, ebook that I'm going to be putting out in about 5 weeks or so. And if you're interested in a different way of managing your contracts, this is going to be an ebook for you, and I hope that you will sign up to take a read when it comes out. So today's topic is on kind of one of those technical, lawyery, geeky contract things called the Force Majeure Clause. Now, a Force Majeure Clause is basically a clause that says, holy crap, something bad happened and now we can't perform our contract. It's essentially what it boils down to. And usually things that fall into this category are things like a fire, a flood, other natural disasters, earthquakes, a hurricane, for example, or, maybe there's a riot, maybe there's an act of the government, an act of God, something like that, that prohibits the parties from being able to complete the contract for whatever reason, or to delay performance for whatever reason. And usually it's involved something like, we're not going to be liable if there's an act of God, a natural occurrence, a war, or something like that, that prohibits us from being able to perform. Now, the question that often gets kicked around in geeky lawyer contract circles is whether or not this clause is actually necessary. For the most part, it probably isn't. And here's the reason why. Okay, real quick warning, geeky lawyer questions coming up. There's something called the doctrine of impracticality. Used to be called the doctrine of impossibility, but essentially it states that if it becomes impractical through some sort of superseding event beyond the control of the parties, then the contract doesn't have to be performed, or it may be modified by the parties in order to account for that superseding event. So, for example, I had a colleague of mine in a case that we were working on was in Puerto Rico. And a hurricane came in Puerto Rico, as you might recall, and basically the entire island was without power. She was able to contact me. We were able to do an extension of what was going on, but that's the kind of thing that happens. It was impossible for her to conduct the activity that she needed to be able to do, communicate with her clients, because her client was also on the island, to be able to communicate with me effectively, to be able to communicate with the court effectively. So we were able to come up with some sort of accommodation, and the court was quite kind. In the contract world, you're looking at the same kind of thing. If it becomes impossible through some action not related to what the parties have done that makes it impractical, either from a time perspective, a delivery perspective, if it makes it impractical to perform, then the contract should be either terminated or modified in whatever way might be necessary without any liability to the parties. That's the doctrine of impracticality. There's also something called the frustration of purpose, which is a little bit more difficult to explain, but one of the best cases to explain it is an old case out of Britain, actually. A gentleman wanted to rent a room with a view into the coronation for King Edward VII, I think it was, and he was unable to use that room because the coronation of King Edward was postponed because King Edward got sick. So there was a frustration of purpose. The whole purpose of the contract was to have this room overlooking the coronation. Coronation didn't happen due to anything that the parties did, so it frustrated the purpose of the contract, and the contract was then void. All right, they sound a lot alike, those two doctrines. But what's important to remember is those two doctrines exist if you don't have a force majeure clause in the contract. So, if you have a force majeure contract, you have to be very specific. You have to make sure it happens. So, I've been asked on many occasions to include a force majeure term in the contract. I don't like doing it largely because it's a very legalese kind of thing, and I don't like a lot of legalese. But if you're going to include it, this is one thing where you and your lawyer need to sit down and you really need to think about what could happen that could frustrate that could prevent the performance of these parties. And think beyond, riots or floods or fires or things like that. You got to think about what could happen between these parties, what could happen to the relationship, and what outside forces are working upon that relationship. So the key thing that you have to remember is that if you put a force majeure clause in there, the law does not allow you to then fall back on the doctrine of impracticality or the frustration of purpose doctrine. You don't get that option. You have decided to put in your own clause, and in doing so, you take away these sorts of things that kind of sit in the background of contract law if there's a dispute. And another important thing that you need to make sure is in a force majeure clause is a notice provision. The party who's affected by the outside force needs to give notice to the other side that, hey, this thing happened, and B, this is what we're doing to try and address that. Maybe we need another 4 weeks. Maybe we need another 2 months. Maybe we need to address this particular problem between us before we move on with the contract, or maybe it's worthwhile that we simply terminate the contract. It doesn't matter what the plans are going forward. It matters that notice is given. So you need to communicate with the other side and make sure that they understand what's going on. As a practical rule, I don't like force majeure clauses. As I said before, they're very legalese and they're not very helpful into helping the parties understand what's going on. The parties need to be encouraged to communicate if there's problems. And if there's a factor that happens beyond the control of the parties, they should be communicating about it. But you want to encourage that in other ways. You want to encourage that kind of communication. And then rely upon these gap fillers in the law, the doctrine of impracticality, to cover you in the event something big happens that neither party can control and that neither party can easily recover from. So, force majeure clauses. I know it's a little contract geeky, but if you come to me and ask for one, we're going to have a long conversation about whether or not you actually need one. In the meantime, go out and watch some live soccer. This is Matt the Lawyer signing off. I'll speak to y'all later.